not for nothing, but Donald Trump Sr.'s record with airlines. Didn't he bankrupt an airline because he was too goddamn stupid? Didn't he have like a regional carrier and he kept trying to stick like 40-pound gold sinks in the bathroom?
Trump Airlines, yeah.
Trump Air, right, along with Trump steaks and Trump vodka, whatever. The point is, the crashes had nothing to do with mandatory DEI in the airline industry.
Of course not.
Boeing screwed up and Boeing lied. And that's why it's going to have to, plead guilty to fraud. Welcome to Law and Chaos, where today, Donald Trump is not the craziest guy on the docket. I'm as shocked as you are. Today, we've got North Carolina's Lieutenant Governor Mark Robinson suing CNN for digging up his digital past, and Judge Reed O'Connor in Texas holding up a multi-billion-dollar settlement agreement with Boeing because it's too woke. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye. With me, as always, is Andrew Torres.
Hey, Liz, how you doing?
I'm doing okay. How are you?
I'm okay. I mean, I think that you won our bet from last week's show, but you won it in the best way possible, so I'm not too salty about it.
Did I? You know that song, Alice's Restaurant, is like the greatest Thanksgiving song ever written. In the song, I'm going somewhere with this, you guys, I promise. Arlo Guthrie sings something like, "Now, friends, there was only one or two things that Officer Friendly could have done. And the first was he could have given us a medal for being so brave and honest. And the other was he could have bawled us out and told us never to be seen driving garbage around the vicinity again." Right? So that's the whole setup of the song. He gets arrested for littering. And then he says, "But when we got to the police station, there was a third possibility that we hadn't counted on, and we were both immediately arrested." And I say this because I said on Friday's show that Donald Trump was going to immediately appeal this order, unsealing the special counsel's appendix to the immunity motion. There's going to be this document with 27 8x10 color glossy photographs with circles and arrows and a paragraph on the back of each one explaining the evidence to be used against him. That's just a little joke. And you said that he was going to do nothing. And so we bet $5 on Friday's show. But it turns out, like in Alice's Restaurant, there was a third possibility that neither one of us had counted on. And it was that Donald Trump was going to file the same stupid brief he's filed 5 times now, asking her to push off the disclosure of this document until after the election. Only this time he was going to do it with 60% less invective. And he wasn't going to do it immediately. He was going to do it just a few hours before the deadline, making it virtually impossible for him to appeal an adverse ruling.
Liz, as I'm thinking about it, I think that song might be about the draft. Anyway, you should go listen to Alice's Restaurant. It's amazing. But just to refresh our listeners, last week, Judge Chutkan gave Donald Trump a 7-day stay of her order authorizing the public release of said appendix to special counsel Jack Smith's immunity brief. That is the documentary evidence supporting the factual allegations in that brief, right? Including the new facts showing that Trump absolutely knew he lost the election in early November of 2020. And man, we cannot wait to see those documents. So Judge Chutkan had given Trump 2 weeks to lodge any specific request to, further redact that appendix. And, Liz, as you said on the show, this is an area where Trump's lawyers could have made real arguments, right? Because that appendix is going to contain grand jury testimony and other sensitive documents. There are valid, real law reasons to, restrict some of that information from coming out before trial.
Right, from which you all may infer that Trump did not file such a document. Instead, he howled that nothing could be released because it would amount to election interference. At which point Judge Chutkan said, "Defendants' concern with the political consequences of these proceedings does not bear on the legal issues here." And she told him that, quote, "future filings should be directed to the issues before the court," i.e. stop docketing these tantrums filled with irrelevancies that have nothing to do with the issue at hand. That was the same filing in which she excoriated his lawyers for a pattern of defense filings focusing on political rhetoric rather than addressing the legal issues at hand, and calling it, quote, "unresponsive and unhelpful to the court, and also unbefitting of experienced defense counsel and undermining of the judicial proceedings in this case." which it was. So last week, Trump's lawyers requested a 7-day stay of the public release of the appendix to, quote, evaluate their litigation options, which was the basis for our bet on Friday. And honestly, Andrew, I think we kind of both lost. Like, I said they definitely appeal, and you said they do nothing, and they did something, sort of. I mean, they filed the same document again, only this time they were like slightly less obnoxious about it. Their theory is that Trump's own response is due on November 7, at which point we'll do this same dumb dance over the redactions for another week, and then the document will appear publicly on November 14th. And so to mitigate the appearance of election interference, the court should put off the release of this special counsel's appendix until the 14th, which just so happens to be after the election. Who knew? They say, although the court has decided over President Trump's objections that the political consequences of these proceedings is not a cognizable legal prejudice, the court has not addressed the public's interest in ensuring that this case does not unduly interfere or appear to interfere with the ongoing election. A temporary stay would serve that interest by ensuring that the redacted appendix is accompanied by President Trump's rebuttal, reducing, but again, not eliminating, this case's improper impact on the election, as well as the potential for voter confusion. Additionally, a stay would promote public confidence in the integrity of these proceedings and a court's duty to remain apolitical.
I don't know where to begin. Like, every word of that is wrong. So, okay, let's talk. I suppose I should say at the outset that saying, hey, you told us that the political consequences don't matter, but have you considered the political consequences? It's probably not a great argument to make before Judge Chutkan. No. Yeah, but let's talk about the law here, because what the special counsel's office has done, as we've said, is filed an appendix that contains the factual support for their summary statements that are in their brief. That's a totally normal thing to do when you are filing a dispositive motion. If you are opposing that motion, you can file your own appendix, right, to your own opposition and say, you should also look at these documents, but it never happens. Never in litigation that those appendices are filed simultaneously, right? Like, you file your appendix when you file your brief. Judge Chutkan entered a briefing schedule. So this argument is just, it hurts my brain to read it. And then I have to say, I really like how John Lauro, Trump's counsel, ends this desperation pleading by saying, counsel for President Trump requested a position from the special counsel by email on October 16th, 2024, and again on October 17th, 2024. At the time of this filing, the special counsel has not responded, from which I infer that, they emailed Jack Smith at like 11:58 p.m. on Wednesday the 16th, and then at 8:57 a.m. on the morning of the 17th, right? Because this document was docketed at 9 a.m. sharp, right? So presumably Judge Chutkan is just going to sign one order denying this request, unsealing this appendix, sadly, after we have to record this show. and like, by then it will be too late to appeal, right? Like, that it will be released. You can't put the genie back in the bottle. So, almost like Trump's lawyers did nothing at all.
Okay. That is completely fair. Although I will say we are recording this at 1:30 in the afternoon, and perhaps some crazy shit happened after we sat down together and, I don't know, Chief Justice Roberts and Sam Alito dove down from on high and saved.
I pulled an Eileen Cannon and, sua sponte, we're waiting to Reed to intervene. Yeah, I did. Unless you want to go double or nothing on the $5.
I do not, sir. I do not.
Okay. And I should say, for what is, I think, the first time ever, we're going to put our deep dive geekery on Trump in the Patreon bonus. Because look, the real takeaway here is that the special counsel's office and Judge Chutkan are doing their level best to uphold the rule of law, despite the active interference by the Supreme Court and, Trump-appointed judges and the truly insane, non-stop litigating by Trump's lawyers, who, I feel compelled to remind you, are being illegally paid through Trump campaign donations. But, I guess we don't have time for that either.
No. All right, let's move on, because we have some good news on the election front. First up, in Georgia, where Judge Robert McBurney has issued an injunction on a new rule from the state election board, which would have mandated that every precinct had to do a hand count of the ballots on election night. We talked about this in episode 67. Basically, the rule would require 3 election officials in every precinct, including the poll manager, who is presumably in charge of everyone else, to stop whatever they're doing after the polls close and, quote, independently count the total number of ballots removed from the scanner, sorting into stacks of 50 ballots, continuing until all of the ballots have been counted separately by each of 3 poll officers. That's from Judge McBurney's order. And if there is discrepancy with the count reached by the machines, the officers should, run around like headless chickens trying to figure that out. This is basically a placeholder for Republicans to cry foul after the election based on minor discrepancies and then throw sand in the gears, possibly to the extent that it would give them an excuse not to certify the election results.
Yeah, 3 shall be the number of the counting, and the number of the counting shall be 3. 5 is right. Oh, look. Seriously, full credit to Georgia Secretary of State Brad Raffensperger. He said from the get-go that this was unworkable, and he would not be able to issue advice to various election officials as to how to implement it, right? Your chicken comment, right? Also, continuing shout out to Judge McBurney, who, 2 weeks ago wrote that opinion that we covered on the show, tossing Georgia's abortion ban, even though he knew, correctly that the state's high court was going to overrule him. It just seems like a stand-up guy. And, as a legal journalist, a really excellent writer. I have to say, it's a joy to read his opinions. Anyway, here's what he said on Tuesday when he enjoined this rule from going into effect. He said, Petitioner and petitioner intervenors have further demonstrated how the 11th and 1/2 hour implementation of the hand count rule will make this coming election inefficient and non-uniform by the introduction of an entirely new process, the precinct-level hand count, that involves thousands of poll workers handling, sorting, and counting actual ballots in a manner unknown and untested in the era of ballot scanning devices. No training has been administered, let alone developed. No protocols for handling write-in ballots have been issued, and no allowances have been made in any county's election budget for additional personnel and other expenses required to implement the hand count rule. The administrative chaos that will, not may, ensue is entirely inconsistent with the obligations of our Board of Elections and the State Election Board to ensure that our elections are fair, legal, and orderly.
Right. So he said the rule was, quote, too much too late, and that the public interest is not disserved by pressing pause here. This election season is fraught. Memories of January 6th have not faded away, regardless of one's view of that date's fame or infamy. Anything that adds uncertainty and disorder to the electoral process disserves the public, which I think is really important because it calls out what these people are doing. Like, under the guise of reassuring the public that our elections are fair, these people are injecting actual instability into the process. Like, this is their solution for the problem that they themselves have created with their fire hose of lies about non-citizen voting and widespread fraud. And that cannot be the solution. You cannot put the rabbit in the hat and pull it out, right?
Yeah, that's some catch, that catch-22.
Exactly. And speaking of good news, on Wednesday, U.S. District Judge Anna Manasco enjoined Alabama's Secretary of State Wes Allen from conducting a voter purge of that state's rolls. So that's good. We like that.
Yeah.
Basically, on August 13th, Allen put out a press release claiming that he'd, quote, identified 3,251 individuals who are registered to vote in Alabama who have been issued non-citizen identification numbers by the Department of Homeland Security, and that he was instructing the Board of Registrars in all 67 counties to immediately inactivate and initiate steps necessary to remove all individuals who are not United States citizens, which sure sounds like they found a whole bunch of non-citizens registered to vote, doesn't it? But of course, that's not what happened. This was always going to sweep up a boatload of naturalized citizens who are entitled to vote and, remove them from the rolls 5 minutes before the election, which it did. It also removed a bunch of people who were born here because they, fat-fingered a form one time or checked the wrong box. And we know that because a group of those people sued the state after finding themselves disenfranchised and forced to bring in a whole pile of documents to the registrar if they wanted to actually cast a ballot. Allen was also sued by the Department of Justice because the National Voter Registration Act imposes a 90-day quiet period before elections during which it is illegal to engage in a systemic voter roll purge like the one Allen just undertook.
Yeah, and if you, maybe like us, have been somewhat critical of Merrick Garland's tenure as Attorney General. This is something where I just want to say the DOJ's Civil Justice Division, led by Kristen Clark, has been working overtime, monitoring every single local infraction. And here, right, they popped up to say, no, this violates federal law, specifically 52 USC section 20507C2, which says a state shall complete not later than 90 days prior to the date of a primary or general election any program, the purpose of which is to systematically remove the names of ineligible voters from the lists of eligible voters, which is explicitly what this is, right? So the DOJ Civil Rights Division sued. Its suit was combined with the one filed by the disenfranchised voters, and Judge Anna Manasco, issued a preliminary injunction saying, no, you can't disenfranchise thousands of voters by fiat. If you find somebody who's dead or moved or is a non-citizen on the rolls, right, you can take them off one by one, but you can't remove whole classes of people systematically. That's preempted by federal law. Incidentally, Anna Manasco is the judge who forced Alabama to redraw its racist congressional districts in a case that went all the way up to the Supreme Court twice. The second time because the state legislature simply disregarded her order and, resubmitted the original map anyway.
Yeah, it disregarded the Supreme Court's order as well. But while we're on the subject, Virginia Governor Glenn Youngkin also announced a vote purge. In fact, he announced it on the 90th day before the election, which was clearly a deliberate middle finger. That was not an accident. And the DOJ sued Virginia and its election chief, Susan Beals, in the Eastern District of Virginia. That case is still percolating through. But I did get an announcement yesterday from the Trump campaign saying that Kamala's weaponized DOJ sued Virginia to keep illegal aliens on their voter rolls. Is that what happened?
No. Look, this has real consequences, right? We've talked about a couple of election cases here, but there are towns, there was a tiny town called Thornapple in Wisconsin where the local city board of governors was like, we got to stop using them machines, right? And so the system they put into place, still requires an optical scanner to, process the ballots, and was not accessible to voters who, were in a wheelchair or otherwise, couldn't access it. Right? And I don't think they were deliberately trying to suppress the vote, but I do think that they were led into this decision that disenfranchised people because they thought there was this, evil Italian space laser conspiracy. Lies hurt real people.
Right. And just to follow up on that, I believe that was enjoined because I think it's the Help America Vote Act, right, that says you have to have at least one machine which is handicap accessible. And
in each voting location. That's right.
In each voting location.
Another more good work by the DOJ's Civil Rights Division. So, and I want to say we're not going to get time to talk about it in depth today because there's so much out there. But on our Substack, we have a fabulous piece that's up by you, Liz, making fun of Missouri's Attorney General Andrew Bailey for being bad at law and specifically for being worse at performative troll suits than Ken Paxton, the evil supervillain Texas Attorney General, right? So they both filed these harassing subpoenas on Media Matters for America for, the crime of being mean to Elon Musk and then getting called out for it on Twitter, right? But Paxton knew that he was just pandering, right? He treated it like a publicity op and, filed his thing, but then sort of meandered off while the subpoena got enjoined because, of course, it did. Bailey lost his mind and wound up making everything so much worse. So this is a classic Liz piece. It's got law geekery. It gets deep into the woods, and it is also very, very funny.
Thanks, Andrew. I'm wondering, do good lawyers go on Don Jr.'s podcast and talk about dropping subpoenas in time for the election? No, I feel like no. I don't know. Something to think about during this brief ad break, unless you are a subscriber at patreon.com/lawandchaospod or on Substack at lawandchaospod.com, in which case you have to think really fast because you're not going to get any ads. And we are back. Okay, for our main story, buckle up, because this one is batshit. It involves Judge Reed O'Connor, the lunatic judge parked in the Fort Worth Division of the Northern District of Texas. You may remember O'Connor from such hits as Personal Jurisdiction is What I Say It Is. That's off the album Twitter versus Media Matters. In fact, he's had a lot of hits, including Employers Don't Have to Pay for Your HI Preventative Drugs because Homosexuality is Grody and Sinful. And also The Affordable Care Act is Communism. Both of those were nationwide hits. In fact, they were nationwide injunctions.
Yeah, and speaking of Media Matters, we told you how in those cases before Judge Reed O'Connor, Media Matters filed what they styled as a motion to clarify Twitter's Rule 26 disclosures, which is not really aimed at Twitter, right, but at publicly exposing that Judge O'Connor owns Tesla stock and yet does not recuse himself from cases in which Elon Musk is a party. And he did not recuse himself from that case, right?
Yeah, so under federal law, 28 U.S.C. Section 455, a judge shall disqualify himself whenever he knows that he has a financial interest in the subject matter in controversy or in a party to the proceeding or in any other interest that could be substantially affected by the outcome of the proceeding, like, say, if you have a lunatic filing cases and he owns two companies and the value of both of them appear to rise and fall with his public lunacy.
Yeah.
Just as a for example.
Yeah, right. And notice that part that you read said that the judge has to know, right? So what Media Matters was doing was documenting for the record that, yes, O'Connor not only owned Tesla stock, but knew he owned it in cases where Musk's other company, Twitter, is a party, right? Or X, I should say. So here's the update. O'Connor.
I'm never going to call it X. Never, never.
You know, when during the merger it was listed as X Corp, right? Like I thought that was honestly just a placeholder in those merger documents, but whatever, here we are. Anyway, Reed O'Connor was required to file the mandatory financial disclosure forms for his 2023 activities. And it shows that he continued not only to own, but to actively trade Tesla stock throughout the year while presiding over a case that could materially impact the value of said stock. And like, this is a judge who definitely market times his sales, right? Like, he doesn't just buy and hold, right? Like O'Connor bought Tesla in January of 2023 when it was trading in the 140s. Sold it in June at 250 or so, then bought again in September at like 252, right? Because market timing is for suckers. Anyway, and his stock has lost about 15% of its value since then, right? It's trading in the low 220s as of this morning. That kind of conflict of interest is why it is really not normal behavior for judges, Democratic appointed, Republican appointed, doesn't matter, to own and actively trade individual stocks, especially the huge market cap stocks of the sort that are in O'Connor's portfolio. He owns about 100 of these, and they are enormous stocks, right? So the judicial form has you code by letter for ranges of dollar values, right? So what we know is that his holdings in Tesla are between $15,000 and $50,000 worth. Look, I want to be clear here. It is probably not mandatory for O'Connor to recuse himself here, right? Like he doesn't own stock in Twitter, in X, right? So the financial impact is indirect, but like it's gross. And this is a thing that judges just don't behave this way.
Yeah, I would note the impropriety of this is really implicated in the decision that we're going to talk about today, which involves a major multinational corporation, which is publicly traded. So, okay. O'Connor is presiding over a criminal fraud indictment filed against Boeing on January 7th, 2021. That indictment came in the wake of two high-profile crashes of Boeing 737 MAX aircrafts. One was Lion Air Flight 610, which crashed shortly after taking off from Indonesia on October 29, 2017, killing 189 passengers and crew members. The NTSB, that's the National Transportation Safety Board, found that Boeing was to blame for multiple manufacturing and training errors that amounted to a design flaw in the autopilot system. And then on March 10, 2019, Ethiopian Airlines Flight 302, another 737 MAX, also crashed, killing 157 passengers and crew from what was determined to be the same autopilot defect, after which the 737 was grounded worldwide for almost 2 years, causing a massive disruption to air travel worldwide. You may remember that. On the same day as the indictment was issued, Boeing entered into a deferred prosecution agreement with the Justice Department. The company promised that if the government would not try and convict it of a felony and put it through the trial, then Boeing would fork over a boatload of money and also agree to keep its nose clean for 3 years, with the FAA all up in its business. Up in its business is not the technical legal term, but that's essentially what Boeing agreed to do. So Boeing says it'll pay a $243.6 million fine plus $1.77 billion in compensation to its airline customers and set up a fund to pay out an additional $500 million to the relatives of the crash victims. That agreement was ratified. It would have expired on January 7th, 2024. But on January 5th, 2024, a panel blew off an Alaska Airlines flight, and that plane was, of course, a Boeing 737 MAX, which meant that the deferred prosecution agreement was off because they pretty clearly, not fixed the production of this plane.
Right. And in the meantime, the surviving family members of the victims killed in the 2 earlier crashes moved to intervene in the case regarding the settlement pursuant to a 2004 federal law called the Crime Victims' Rights Act. And it says that crime victims have various rights. It's 10 or 11, and it includes the right to be reasonably protected from the accused, the right to be reasonably heard at any public proceeding in the district court involving release, plea, sentencing, or any parole proceeding, the right to a full and timely restitution, and the right to be informed in a timely manner of any plea bargain or deferred prosecution agreement. And again, remember, these are criminal charges being brought against Boeing. Corporations are people, my friend, at least, for certain parts of the criminal law. So the family members said that the deferred prosecution agreement violated those rights that they had under the Crime Victims' Rights Act, specifically the rights to be protected from future Boeing crashes, as well as full restitution, because, the crashes were arguably a result of fraud, right? And that case has been up and down to the Fifth Circuit, and it has a complicated procedural history, and the families wanted the Department of Justice to impose criminal penalties and harsher fines on Boeing than were agreed to, right? Along with making it pay more to the victims' families. Understandable. So in 2023, Judge O'Connor ruled that the families did constitute crime victims, but that they did not have the right to intervene to stop that first deferred prosecution agreement, which, by the way, pretty straightforward opinion on its face, right? But if you have ever put a pin in anything listening to our show, put a pin in that one.
Okay. So, as we said, the first deferred prosecution agreement gets blown up. Then, over the summer, the Justice Department and Boeing negotiate a new agreement. But this one is a plea deal that forces Boeing to plead guilty to one charge of conspiracy to defraud the United States. It's got a bigger fine, more money for compliance, more money for the victims, and it involves a compliance monitor. But the victims still object, and that's where Judge O'Connor comes in this week with his wild-ass order. Now, remember, last year, he said that the victims do not have standing to block the deferred prosecution agreement. So there's a hearing last Friday on whether the court should accept the new plea deal. And the sticking point for the court seems to be DEI, as in diversity, equity, and inclusion. I shit you not, because the government says that it will select a monitor taking into account its regular DEI mandates. I'm sure that's just like boilerplate language, right? But that is not okay with Judge Fedsock. He says, like many of the agreement's other provisions, the victims strongly oppose the agreement's compliance monitor requirements. Among other reasons, the victims argue the court should reject the agreement because it allows the government, not the court, to select a monitor with input from Boeing and, quote, in keeping with the department's commitment to diversity, equity, and inclusion. When the court questioned the government on this provision, the government confirmed, quote, it is a policy position of the Department of Justice established in 2021. The government further stated it is something that the department takes into account as it assesses the totality of an application for a particular person or monitor team. In response to the court's question on what the provision means in practice, the government explained that it doesn't mean in practice that the government selects someone less qualified. Rather, it is going to hear from anybody who can submit from all over the country or elsewhere.
Okay. So when I first read that, I was certain that there was a sleight of hand going on here, right? Because Judge O'Connor repeatedly says that the victims strongly oppose the monitor and then drops a footnote citing to the record and then as you just read, implies without stating that the basis for the victims' families' objections were, Boeing and the government's DEI policies. And that seems super weird to me, right? Not the least of which is because the victims are mainly non-Americans, right? Remember, these were flights out of Ethiopia and Indonesia. And obsession with evil woke DEI is pretty much an American export, right? It's not theirs. And their lawyer's job is to get more money for their clients. That's why they were hired, not to rant performatively about wokeness, right? So I went to those footnotes and, you and I, Liz, pulled up the actual objections that the victims' families filed to the proposed settlement. And shocker, turns out most of the victims didn't object to the monitor at all. Those that did so only briefly, often in footnote, and on the basis that what they wanted was truly independent supervision, right? They wanted supervision by the court, not by the government, which was a party to this agreement, right? So exactly 0 of the intervening victims' rights groups, right? The families of the victims, in exactly 0 of their pleadings, ever said anything like, hey, we object to the monitor on the basis of corporate diversity policies. Did not say that. Judge O'Connor is lying by implication.
Right. And that is when it clicked for me what's happening here. That this is right-wing bullshit getting laundered by a federal judge. Because as soon as the Alaskan Airlines door fell off, the wingnuts started yelling that it was because of DEI. Charlie Kirk, who is this, it doesn't matter. If you know who he is, you know who he is. And if not, he's just a right-wing asshole. Kirk says on air, if I see a black pilot, I'm going to be like, boy, I hope he is qualified. And then when he got pushback for that, his producer was like, well, it's your guys' fault for pushing DEI on us. This is the reality the left has created. And Elon Musk said, do you want to fly in an airplane where they prioritize DEI hiring over your safety? That is actually happening. People will die due to DEI. And Don Jr., the former president's son, said, I'm sure this has nothing to do with mandated diversity, equity, and inclusion practices in the airline industry.
I cannot believe that we are relitigating this in 2024, right? These are the arguments that, were dispatched in the first half of the 20th century. Yeah.
Yeah, and not for nothing, but Donald Trump Sr.'s record with airlines. Didn't he bankrupt an airline because he was too goddamn stupid? Didn't he have a regional carrier and he kept trying to stick 40-pound gold sinks in the bathroom?
Trump Airlines, yeah.
Trump Air, right, along with Trump steaks and Trump vodka, whatever. The point is, the crashes had nothing to do with mandatory DEI in the airline industry.
Of course not.
Boeing screwed up and Boeing lied. And that's why it's going to have to, plead guilty to fraud. But complaining that DEI is making airlines less safe has been a GOP thing for years. In 2021, United Airlines announced that it was working to hire more black pilots since 93% of airline pilots were white at the time. And then Tucker Carlson and Ben Shapiro flapped their filthy yaps for 2 weeks about woke airlines getting passengers killed. So keep that all in mind when I read you this next part from Judge O'Connor's order. He says, both the DOJ and Boeing have publicly acknowledged their commitment to advancing diversity, equity, and inclusion. For instance, the DOJ is committed to advancing diversity, equity, inclusion, and accessibility for its employees.
And then Judge O'Connor briefly describes the Justice Department's commitment to, expand recruitment to traditionally excluded communities, which, normal humans tend to think is a good thing, before continuing. And I want you to hear this in the "In a World" guy's voice, right? With the ominous music playing in the background. This is how it continues. Boeing's DEI endorsement runs in the same vein. Its website touts its commitment to creating a culture of inclusion and set of aspirations it will strive to achieve by 2025 to advance equity and diversity and build a culture of inclusion. These aspirations include racial quotas, such as Boeing attempting to increase the black representation rate in the U.S. by 20% and close representation gaps for historically underrepresented groups.
Okay, that's not a quota. It's a goal. And increasing, right, there's 7% of the pilots are non-white. Increasing it by 20% will still be functionally no non-white pilots, but fine. Okay.
Yeah, okay. Judge O'Connor wasn't done. He continues, indeed, Boeing ties executive compensation to achieving DEI goals. The government has confirmed Boeing's fraudulent misconduct has burdened safety and compliance protocols. Accordingly, the corporate monitor's role centers precisely on Boeing's current and ongoing compliance with U.S. fraud laws, specifically focusing on the integration of Boeing's compliance program with Boeing's safety and quality programs as necessary to detect and deter violations of its anti-fraud laws or policies. Given this, the court needs additional information to adequately consider whether the agreement should be accepted. Specifically, it is important to know how the provision promotes safety and compliance efforts as a result of Boeing's fraudulent misconduct, what role Boeing's internal focus on DEI impacts its compliance and ethics obligations, how the provision will be used by the government to process applications from proposed monitors, and how Boeing will use the provision and its own internal DEI commitment to exercise its right to strike a monitor applicant.
Okay, so brass tacks. O'Connor is ordering Boeing and the DOJ to report back to him by October 25th on how DEI is going to play in their selection of a monitor and how DEI is going to make anyone safer or stop Boeing from doing more frauds. And he's willing to hold up this billions of dollars in settlement because he doesn't like woke.
Yeah, and that is money not going to victims of people who died in airline crashes that the airline wants to pay and the government wants them to get paid. It's astonishing.
Yeah, and once again, remember, he's pretending that that's what the victims asked for. That's not what the victims asked for. It's just him parroting right-wing talking points. So, love that. Okay, we are going to have a little more fun when we come back from the ad break, depending on your definition of fun, I guess, unless you are a subscriber, in which case, nope, not for you. All right, see you guys in a second after we pay some bills. And we are back.
Yeah, for our next story, let's talk about everyone's favorite Republican gubernatorial nominee in the state of North Carolina, guaranteed to be among the top two finishers in that race. I am, of course,
get off the ballot.
Talking about Mark Robinson, the current lieutenant governor, who is, running somewhere between 7 and 16 points behind current North Carolina Democratic Governor Josh Stein in the polling. And look, I want to say, we've said this before, Robinson's sexual proclivities should be nobody's business but his own and his wife's, I guess. But once again, this man is making his business our business. So
today, we are taking the first step to do exactly what I said I was going to do after these scurrilous attacks were launched against myself and my family. We are holding CNN accountable. And we are going to get to the bottom of what's going on here. And we are glad to be here today to be able to do that. I said at the very beginning, what this amounts to is, to quote Clarence Thomas, this is a high-tech lynching on a candidate who has been targeted from day one by folks who disagree with me politically and want to see me destroyed. And so we are glad to take these first steps to fight back against what we consider to be one of the greatest examples of political interference in this state's history and quite possibly this nation's history. And with that, I'll turn it over to my attorney, Jesse Binal.
Of course, his attorney is Jesse Binal, right? Drink if you're playing the drink game, or put a pin in it, depending on what time of day you listen to this podcast.
Okay, so in case you all have forgotten or blocked this whole thing out of your mind, Robinson has a long history of saying extraordinarily gross, violent, anti-Semitic, transphobic, misogynistic, hideous shit. And when you're a candidate from public office, people are going to go digging into your business. It's kind of the deal. And Robinson had some stuff that wasn't buried that deep when people went digging. So as he said, he filed this lawsuit. We're going to present to you the events from the suit in the order that he described them. An order which he describes as uncanny. As in, CNN and Lewis Love Money are responsible for a new low in digital lynching. In a malicious hit job so well-timed as to be uncanny, they have published disgusting lies about Lieutenant Governor Mark Robinson in what appears to be a coordinated attack aimed at derailing his campaign for governor and has already inflicted immeasurable harm to his family, his reputation, and his good name. This lawsuit, while utterly insufficient to right this wrong, shall serve as a small measure of accountability. Okay, let's talk about Louis Love Money. Because Mr. Money, who legally changed his name from Louis something normal, sings in a punk rock band called the Trailer Park Orchestra. But back in the 90s and early 2000s, before the internet took over porn, you used to have to go to a porn video shop and either buy the videos and take them home with you or view them in a private booth on the premises. Money worked as a clerk in one of these video shops, and he claims that Robinson came in there like every night at 4 a.m. when he finished his shift across the street at Papa John's. Money also claims that Robinson was such an aficionado that he bought bootleg videos compiled by Mr. Money, who sourced them from New York, where obscenity laws were laxer. And apparently, Robinson neglected to pay for the last video, so Money and his orchestra wrote a song called The Lieutenant Governor Owes Me Money, with a hilarious video which he posted to YouTube in early August. Actually, would you like to take a listen? Come on, you know you would.
Oh, sure.
Hey, Lieutenant Governor, I'm so proud of you. You're the first black man to hold that title. You might not remember that I sure as heck do. Back in the days before the online view. Hey, Mr. Robinson, nail me a check. Hey, Lieutenant Governor, please don't conveniently forget.
Surprisingly not terrible. And the video is very, very funny.
Yeah, we'll link to it in the show notes. But Robinson did not think the video was funny, nor did he think it was funny when Money gave an interview to a North Carolina news site called The Assembly, which Robinson's suit described as, quote, a major online publication with links to George Soros. Don't you dare call him anti-Semitic, though. Okay. On September 3rd, the site published an article entitled Ex-Porn Shop Employees Say Mark Robinson Was a Regular. He Denies It. And as someone who writes about crazy shit every day, can I just read you the holy perfection of this lead? It is perfect. Goes. In his 2022 memoir, We Are the Majority, Lieutenant Governor Mark Robinson wrote that he committed his life to Jesus in the late 1980s. I did not, however, experience a drastic conversion like some do, wrote Robinson, now the Republican nominee for governor. My behavior did not immediately reform. They say sin is fun for a season, and I was in that season. Robinson did not specify how long that season lasted or what sins it entailed, but according to Louis Money, who worked in several of Greensboro's windowless 24-hour video pornography stores, Robinson was a frequent customer in the 1990s and early 2000s. Money, 52, told the Assembly that Robinson came in as often as 5 nights a week to watch porn videos in a private booth. 5 other men, who said they were former employees or customers during this period, also told the Assembly that Robinson visited 2 of these stores, Gents Video and News and I-40 Video and News. Okay. Here is how Robinson characterized that series of interactions in his own lawsuit. In the 1990s, Mark Robinson was a young father struggling to provide for his family. During this period, he worked at Papa John's Pizza, eventually being promoted to manager, where he sometimes managed the closing shift. Nearby was an adult video store where Defendant Money worked. Lieutenant Governor Robinson, who has always been a gregarious, outgoing person, made friends with Defendant Money, who also worked the night shift. He would occasionally bring over free pizza and socialize. More often, however, Defendant Money would come over to the Papa John's looking for free or discounted pizza.
So, just so I've got this right, Robinson is the pizza delivery guy who just kind of happens to stumble onto the set and, winds up with more than he was expecting. I mean, who could have ever heard of such a scenario?
Yes. Well, then on September 25th, CNN's Andrew Kaczynski and M. Steck published a story linking Robinson's online handle Minisolder or whatever, MINISOLDR, to a bunch of extremely graphic posts on adult websites, which is not a crime and honestly nobody's business but his own. We're all in agreement with that. I mean, I think it bespeaks a lack of judgment in a public official, but he wasn't a public official then. Fine. He also made some weirdly racist statements, like calling himself a black Nazi and saying MLK Jr. was a communist who shouldn't be on the National Mall. Look, I will say that Kaczynski and Steck have made a whole industry out of it. That is their beat. They track shit down through people's digital trails. But anyway, Robinson denied it, and he said he was going to sue CNN, and he announced that he had hired Donald Trump's own lawyer, Jesse Binnall.
Now it's time to pull that pin, and if you would buy, drink. Binnall is a frequent character in these here parts, right? Whenever a new garbage lawsuit gets filed, Liz and I sometimes play this game called Guess the Lawyer. So whoever pulls the filing first will, text the other one and say, you'll never guess who put their name on this thing. And the other one will say, ooh, is it Harmeet Dillon? Is it Jesse Binnall? Because MAGA dipshits do love themselves a good performative troll suit. And Jesse Binnall is making a fabulous living filing them, right? He was on Sidney Powell's team when she blew up the Mike Flynn prosecution with an assist from Bill Barr. Good Lord, I guess that counts as a win of sorts, right? Binnall represented the Trump campaign in a failed challenge to the certification of the vote in Nevada in 2020. He represented Trump in his failed attempt to block the January 6th committee from getting his presidential records. He represented Flynn and his brother in failed defamation suits against CNN. He's counsel in Trump's appeal of the dismissal of his RICO clown suit against Hillary Clinton in Florida, for which the prior lawyers were sanctioned, right? Binnall represents that dingus Tony Bobulinski, who is suing Democratic Representatives Dan Goldman and Jamie Raskin for, saying that he was full of shit, which he is. He's represented former Congressman Devin Nunes' family in the suit against Hearst magazines that, forced them to admit that, okay, yes, they probably do hire undocumented immigrants to run their dairy farm. And of course, Binnall represents a bunch of truly horrible people attacking trans kids in court as well. So TLDR, that guy's an asshole who pretty much always loses, attaches his name to some extremely questionable litigation. And this one, I think fair to say, no exception.
Yeah, I should note that Binnall is not a member of the bar in North Carolina. The local counsel is a firm called the Envisage Law Group. Lawyers from Envisage also represent Tim Pool in his troll suit against the Harris campaign. And also they represent Alex Berenson, a COVID troll, in his lawsuit against the Biden administration for saying that Berenson was a dangerous purveyor of misinformation, which he absolutely was.
Mm-hmm.
And I know this is all kind of inside baseball, but okay, this is a law show and these lawyers suck. So we're going to name and shame them.
Agreed. So now let's talk about Mark Robinson's actual complaint that Jesse the Boy Wonder filed in Wake County Superior Court.
More like Woke County Superior Court. Am I right?
On the off chance that you were making a joke about recent North Carolina polling and, not the world's silliest pun, I'm going to plug the fact that
I think she can do it.
Boy Wonder, Joe Dye, and I are going to record a show in the next couple of days talking about those polls. But okay. Robinson is suing Mr. Love Money and CNN for $50 million to make up to him for damage to his reputation, which seems like might be overvaluing a bit. He denies all of the allegations categorically, although I should note that WRAL News, the NBC affiliate station out of Raleigh, said that a bunch of Robinson's campaign staffers left last month after the candidate refused to allow tech specialists to poke around his digital life to figure out if, that was really him or not, which does not suggest that he's going to enjoy discovery if this case ever gets that far, which it won't. Okay, so look, there are a lot of ways that these guys signal loud and clear that this lawsuit is not serious, right? So let's read this allegation. CNN, a politically left-wing media outlet whose reporting is often indistinguishable from Democrat Party talking points and opposes politically conservative candidates for office, including Lieutenant Governor Robinson, intended to damage Lieutenant Governor Robinson's gubernatorial run. CNN published the article and attributed the mini soldier, it could be mini solder, I don't know, anyway, posts to Lieutenant Governor Robinson, despite harboring doubt over their veracity and the verifiability of the supposedly supporting information, and deliberately avoided the truth. And look, that's not a thing that you say in real defamation litigation, right? That's a press release. And not for nothing, it makes a conclusory allegation with no supporting documentation, right? Like the point appears to be that Robinson's data could have been stolen, including his email, and there could have been someone impersonating him on all these forums. And like, that's not CNN's job.
Right. If so, that person impersonating him is someone who lives pretty close to him, since Politico matched the IP address to Robinson's town. Also, they say that Robinson's leaked data showed him using a password that is, quote, nearly identical to a password used by 3 separate accounts registered under his wife's email address on non-pornographic websites. Which is not proof, but I would say it's suggestive. I don't understand this thing, like, from an OPSEC perspective. Look, you and I are not techies, but either it was his IP address or it wasn't. Right?
Yeah.
I mean, it could be spoofed,
I think that's right.
but in 1997, really?
So, we have some tech gurus who listen to the show. Maybe one of them can clear that up for us. If so, shoot us a note. But look, what is clear is that the lawsuit is pretty hand-wavy on the actual North Carolina defamation law part, right? So Robinson alleges defamation and defamation per se against both defendants. He is definitely a public figure, so the relevant model jury instructions in North Carolina tell us what he would have to prove if this case ever went to trial.
It's not. Spoiler, no, that's not going to happen.
Yeah, no, definitely not. So I am making the classic mistake I always do on our show, Liz, of pretending that this is real law, but play along with me for a minute, right? Because North Carolina's defamation law is pretty straightforward for the most part, right? Like when you're a public figure, like the lieutenant governor of a state, and you allege someone has defamed you, you have to prove first that the defendant actually made that offending statement.
Which is not even alleged that about the porn shop owner / musician, like Mr. Love Money. Robinson claims that Money made a music video that makes fun of him, which, if that were against the law, Kendrick Lamar would not have a career.
I'm going to pretend that I know who that is. No, okay,
you know who that is.
I know who that. I do know who that is, but I'm doing a bit. Okay,
I told you. Oh, you only know because I told you like a month ago.
That. Wait for my defamation lawsuit against you in North Carolina, Liz. Okay. Also, under the law, you have to prove publication, and then you have to prove that the offending statement was actually false, right? And those three are all standard elements of defamation. They are all adjudicated on the preponderance of the evidence, the typical civil standard, more likely true than false, 50.1%, right? But the fourth element, because he's a public figure, is New York Times v. Sullivan actual malice, which we've talked about a lot. That is defined as either actual knowledge or reckless disregard of the statement's falsity, right? And here's where North Carolina law is a bit different and way worse for Mark Robinson, because A, you have to prove that actual malice by what they call clear, strong, and convincing evidence, right? That is more akin, if the regular standard is 50.1%, to like 75% likely. And it is the highest burden a party can have in civil proceedings. And B, North Carolina case law makes it clear that you cannot meet that burden. You cannot introduce evidence to prove New York Times v. Sullivan actual malice by showing what we might think of as colloquial malice, bad intent, that the defendant hates you. You need objective evidence that the defendant was aware, or probably aware, that the claims were false and published them anyway. And we will get back to that after this brief ad break, unless, of course, you're a subscriber. And we're back, and, you have probably inferred that Mark Robinson's allegations against CNN are basically nothing but bad intent, right? Like, Liz, you read Jesse Bienal calling them a politically left-wing media outlet, who's regurgitating Democrat Party talking point. And the point is, that's irrelevant to the North Carolina legal standard, even if it were true, which not.
Right. And in their press conference, Bienal seemed to admit that he had no proof that CNN knew its reporting was wrong, if it was, which, look, other than Robinson's denials, there have been zero indication that it was wrong. Bienal just says that they're going to get discovery and prove that CNN relied on hacked data, which is inherently unverifiable. Ipso facto, that's recklessness. But okay, Andrew and I are not North Carolina practitioners, so we just looked at the complaint and said, seems like he's kind of yada-ing over actual North Carolina law here. Like most real lawsuits, we'll have at least a couple case cites and references to actual statutes with numbers. And outside of the jurisdiction and venue section, which is more or less boilerplate, this one did not. But again, that's why you talk to someone local, because local rules are not the same everywhere. And so when I checked the docket Wednesday, there was already a motion to dismiss filed by Mr. Money and his actual local counsel, a seasoned litigator named Andrew Fitzgerald. Because it turns out that Local Rule 8A2 says, in all negligence actions and in all claims for punitive damages in any civil action wherein the matter in controversy exceeds the sum or value of $10,000, the pleading shall not state the demand for monetary relief, but shall state that the relief demanded is for damages incurred or to be incurred in excess of $10,000. And then it goes on to say that you can come back later and say specifically how much you want, but you can't say, put it in your pleading and then go on TV and say, we just sued CNN for $50 million.
Yeah, this is a really interesting local rule, like not the least of which is, as we've talked about on the show before, in order to get into federal court for purposes of diversity jurisdiction, the amount in controversy requirement has to be at least $75,000. So this seems like it would make it harder to remove from state court to federal court because you wouldn't be able to say they've sued us for, some amount over $75,000. It could be in that sort of ambiguous zone.
Right. But I mean, the whole point is you can't file for some crazy amount of money and then use it as functionally, a press release.
Exactly right. And in fact, the rule's actually a little better than that even, right? Because Mr. Love Money is asking for dismissal of the lawsuit and his costs. So his lawyer says, the rule particularly and expressly applies when punitive damages are pled, as here. Its purpose is to prevent excess demands from leaking publicly in the media and tainting the judicial process. That policy was highlighted in a case called Shell versus Coleman. In Shell, the Court of Appeals affirmed dismissal of the complaint based in large part to media coverage that resulted from the violation of Rule 8A2 that was far less comprehensive than what could be expected and occurred here with a sexually and racially charged governor's race in a key swing state. And then there's the swipe at Beanall that I'm here for. In fact, given the seniority of the counsel signing Mr. Robinson's complaint, it has to be considered that the violation of Rule 8A2 may have been for the very purpose of creating media attention for Mr. Robinson's campaign by creating a rambling narrative regarding CNN, Mr. Robinson, and the man who did an obscure music video poking fun of Mr. Robinson for frequenting a pornography store, which the complaint seems to at least partially agree with, at least as alleged in paragraph 15, and for owing him $25. Somehow, according to Mr. Robinson, that caused him $50 million in damages. And we're having a good laugh. We should say we have heard from North Carolina practitioners on social media that the case is unlikely to get dismissed for this. And even if it was, right, they could just amend and refile. And then worse still, Robinson is probably not going to get sanctioned for this. But it really does highlight that this thing is a publicity stunt. It is not real litigation. And this pleading is just an absolute faceplant by Beanall. So that's amazing.
Yeah, you do indeed love to see it. All right, if you are a subscriber, you will get the Patreon bonus, which is about Trump's tomfoolery, shenanigans. It's actually a pretty good nerdy deep dive. And for everyone else, we will see you on Monday with more written content and then on Tuesday with another episode of the show. So thank you guys and have a lovely weekend.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Up to Media, LLC, all rights reserved.